Hello, everybody. Welcome back to Clat Tutor. I am Leherjan, a second year law student at the National Law School, Bangalore. And today we're going to be studying the law of torts. The second Latin maxim is damnum sine injuria, which means that damage without any infringement of a legal right. It also means that any damage which is caused to a person where there is no legal injury that is caused, that does not amount to a tort. The last legal maxim for today is injuria sine damnum, which means that even if there exists a legal injury where the person has not suffered any actual damage in the form of financial or any other form of damage, it still amounts to a tort and there is a remedy for the same. Let us look at two examples where injuria sine damno was recognized by courts. First is the case of Ashby versus White, where the plaintiff was a qualified voter who was registered to cast his vote. And then he was wrongfully restrained or detained by a returning officer. In this case, the court recognized that even though the party that he was going to vote for won the elections, so there is no actual damage, but there is a legal injury because he did have a right to cast his vote and he was prevented from doing the same. And hence, the principle of injuria sine damno was recognized. A similar situation happened in India in the case of Bhim Singh versus State of Jammu and Kashmir, where the plaintiff was a member of the Legislative Assembly and he was detained by the police and stopped from attending an assembly session. The Supreme Court recognized that there was no damage which was caused by this detention. However, there was a legal injury because he did have a right to attend that assembly meeting. And the Supreme Court ordered damages of rupees 50,000 rupees to him. Now, when we look at damnum sine injuria, again, there are two very famous cases which lay down this principle. The first is the Gloucester Grammar School case, wherein a rival school was started right in front of the first school, as a result of which there were huge losses which were suffered by the latter, and the latter also had to reduce their fees. The court recognized that this does not amount to a legal injury, as there is no right for you to have a monopoly in an area, which means that, and the court gave an example wherein if a mill was opened and a rival mill was opened right next to this place, which led to a diminishing in profits, this does not amount to a legal injury and there is no cause of action for the same. The second case for today is Action versus Blundell. In this case, the defendant dug up a coal pit right under his land. Now, it is a legal right that all of the materials below one person's land belongs to that person. Now, because of digging up a coal pit, this affected the neighbor's well and the water levels in the same. However, the court recognized that the person was only enjoying their own personal legal rights. And hence, although there is damage caused in this case, there is no legal injury. In order to quickly go over the different forms of torts, there is negligence, assault, battery, and false imprisonment, public and private nuisance, trespass, defamation, and strict and absolute liability. Now, all of these torts can be categorized into three different categories. First is intentional torts, where the aspect of an intention of the person committing the tort is also considered. Second is property torts, where this contains trespass and theft and is related to a person's ownership of property and the effect on the same. And the last category is negligence, nuisance, and defamation. First, addressing intentional torts. It must be noted that there must be an intention to cause these crimes to actually amount to a tort. Firstly, the tort of assault, wherein any act is intentionally and voluntarily done by the accused, which causes a reasonable apprehension in the mind of the person that any hurt will be caused through it. For example, if a person holds up a gun in front of another person and threatens to shoot him, this amounts to assault. Even picking up a stick and pointing it at a person amounts to assault. However, if a person holds a stick at the back of somebody else, this would not amount to an assault because it would not create a reasonable apprehension of harm in their minds. The second intentional tort is battery, which this normally follows the tort of assault, wherein actual association is caused with that person, which causes harm or offensive contact. Which means if a gunshot is actually fired at that person, or that stick is used to hit that person, this amounts to battery. There are cases where assault and battery would not go together. For example, if a person is hit from behind, then assault is not caused in such a case. Or if a person only points a stick at the other person but does not hit him, then there is no battery, but there is assault. The last category of intentional torts is false imprisonment, where the person is intentionally confined to a small space without letting that person to freely move around. This must be caused without having any legal authority. The second category of torts is property torts, which consists of trespass and theft. It must be noted that both trespass and theft are also considered to be criminal offenses, and they are also considered to be torts. So they are an area where an overlap between civil and criminal law actually occurs. In the case of trespass, it is committed when an individual intentionally enters upon the land of another without having any reasonable excuse. Now, this is also a case of injuria sine damno, where there might not have been actual harm that is caused to the plaintiff. However, it creates a violation of a legal right, which is actionable. The second property tort is theft, wherein a person intends to dishonestly take away any movable property out of the possession of another person and moves it in order for such taking. This would also amount to a tort. Moving on to negligence, there are three conditions which must be fulfilled for something to qualify as negligence. First, there must be a duty of care, which means that an individual must, according to reasonable standard of care, have such a duty to follow that reasonable standard. Courts have adopted a third person reasonable standard in this present case, wherein an individual's duty is compared to the duty a reasonable person in the same situation would have had. The second is a breach of that duty. An act or an omission which breaches such a duty amounts to negligence. However, there must be an injury that must have occurred as a result of this breach of duty. There must have been causation, which is that this breach of duty must have caused the injury, and there must be a direct and absolute link between the two. The aspect of causation also includes within it the aspect of remoteness, which means that if something is so remote that it could not have been foreseen by the accused, then it does not amount to a legal injury or negligence. For example, if a person shoots another person in the head and a third person who is looking at the situation from a terrace dies out of shock, this third injury of that person is considered to be so remote that it could not have been foreseen by the accused and hence does not amount to negligence. Moving on to nuisance. Nuisance basically means that a person interferes with another person's right to enjoy their own property. Nuisance is of two types. First is private nuisance, and second is public nuisance. If an individual interferes with another individual's right to use their own property, and this interference is unreasonable or unlawful, it would amount to nuisance. For example, playing very loud music really, really late at night in a residential area. Secondly, the concept of public nuisance is when the interference is related to the rights of public in general. For example, if a person builds something extending out of their house and onto the road so as to interfere with people's right to move around freely, this would amount to public nuisance.